Sex crimes against children with disabilities go unrecognized. Children with disabilities are sexually assaulted at 7 times the rate of people without disabilities, according to the U.S. Department of Justice. It's a crime that often goes unrecognized and unpunished. No one should face sexual abuse. The insider-exclusive Justice in America news team has investigated horrendous incidents of sexual abuse and pushed for reform to ensure these assaults are promptly reported and investigated. And in this special, insider-exclusive Justice in America Network TV special, we visit with Bob Jennis, founder of Sonnen Jennis Law Firm, who represented a 13-year-old child who lived in a residential treatment center for children where he was sexually assaulted because the facility failed to properly protect him. Bob successfully won a $10.6 million verdict for his client for his pain and suffering and future care. Bob has earned a reputation as an unyielding trial lawyer who repeatedly represents individuals and families and repeatedly wins. He has earned the highest respect from citizens and lawyers alike as one of the best trial lawyers in New York. He's built a substantial reputation by consistently winning cases other law firms have turned down. And his amazing courtroom skills and headline-grabbing success rate continue to provide his clients with the results they need and the results they deserve. This is the Insider Exclusive, live from New York. It is my great pleasure to introduce Bob Jennis to the show. Welcome to the show, Bob.
Thank you, Steve.
Tell our audience a little bit about your firm. What type of law does your law firm practice?
Our firm practices Sonnen and Jennis. Our office is in the Bronx, but we've tried cases in 7 states. We do plaintiffs' personal injury medical malpractice. We represent the families of people that have been killed or seriously injured by the negligence of others. We've been doing this since 1988. I've been doing it since 1983, and we're considered a pretty good firm. We work real hard.
Now, in your spare time, I understand you're active within New York State Bar, right? You teach classes. Tell our audience a little bit about that.
Sure. I teach a lot, mainly with the New York State Trial Lawyers Institute, New York State Trial Lawyers Association, where I'm an emeritus director. I've been their director for over 21 years. I'm in charge of the New York State Trial Lawyers Institute program on evidence. It's called Evidence to Win. We do that all over New York State. I also co-chair Depositions to Win. I teach a lot of different classes for them and many other different bar associations throughout the state and the country. I've taught on a national level for AAJ, American Association for Justice. I've taught at the Masters in Atlanta with Don Keenan. I've taught all over the country.
Right, and lawyers really need to go to some of these seminars, if you will, in continuing education, because you don't learn this in law school, do you?
Absolutely. You don't learn any of these skills in law school about how to try a case, and that's what we like to teach, and the law of how to try a case.
Today we are here talking about a case, very sad case, about a 13-year-old that was sexually abused. He was developmentally delayed, right? Tell our audience a little bit about the facts, please.
This was such a sad case. This poor child, on many levels. He was a big 13-year-old. When I say big, he was 6'3", 330 pounds. And what happened was the county took him away from his mother for alleged neglect. Not that she was starving him or beating him or hurting him, but that he was too big. But the whole family was big. They're just wired that way. So they take this child away and they put him in a facility where he's the only kid there because he's too big. Every other kid there is what's considered a juvenile delinquent, awaiting criminal trial and evaluation by psychologists and psychiatrists to see how they should be prosecuted. So they put him in a place where every kid there is a bad kid except for him.
And probably older, too.
And well, his roommate was his age, and part of the defense was that the roommate was actually a fraction of his size, maybe 100 pounds. But it has nothing to do with size. The roommate was a bad kid. They knew he was a bad kid, and the facility did a number of things wrong. The first thing they did wrong was they had a special dorm, or because it's a whole campus, just for people who were developmentally delayed. they didn't put my client there.
Right. And how was he developmentally delayed?
He was born that way. He was born with certain mental deficits. He had autistic features. He was a 13-year-old boy, but he was really mentally a little child. So they put him in, as I say, in the wrong dorm with a really evil, bad kid who had a long criminal record at the age of 13. The other child's mother would not allow him back in the home because she feared for the safety of her daughter. So this was putting gasoline, lighting gasoline to a fire. And they put these kids together, and there were complaints about this other kid being a bully. And the place knew he was a bully and tended to bully, like bullies do, those that were weaker than him, those that were not as aggressive as him. Those just couldn't do it. So one night, the boys are in the room together, and my client is playing with his toys, little action figures, in his bed. And the other boy goes over to him and starts to perform oral sex on him, and then tries to sodomize him. And finally, there was no supervision that all this is taking place. Finally, somebody noticed it. They caught them. They still didn't want to call the police. My child called his mother, and she called the police. The police, when they testified, actually said that normally, if the facility calls them at all, the facility would wait a week before letting the police know.
Seriously.
Okay? So and what the facility tried to do was blame the children. What they said was, oh, this was just sexual exploration by young adolescents. It was play. They consented. The director of the facility, when I cross-examined him at trial, I had subpoenaed everybody, they admit, first of all, there's parent safety rules of the road. They have to act as a reasonably prudent parent would. They are responsible for this child. He is in their exclusive care, custody, and control. They have a duty to watch him, to supervise him, to monitor him, to safeguard him. And they failed abysmally in this. And as I said, it was one thing after another that they did wrong that caused this to happen. And then they would try to cover it up. And the most heinous thing about this is when the director admitted a child of 13 cannot consent. A developmentally delayed child cannot consent. You cannot consent to sexual abuse at that age. And that he tried to blame this children, I think, offended the jury highly.
What were some of the unique aspects of this case and the challenges you faced?
Well, a lot of different challenges. One, you have a client that's difficult for him to communicate what happened. Easy to cross-examine. You have a 13-year-old boy who was developmentally delayed and had autistic features. It's hard to assess. One of their defenses is he's so messed up, he doesn't even know what happened. He's fine, didn't affect him at all. Basically, it's good for him. Let him do it again. He likes it. Okay, it was horrible, the defenses that they used, but through cross-examination, we were prepared to the nines to cross-examine their defense psychiatrist who had an impeccable background. We took him apart and the jury saw through it.
Yeah. Now you were awarded a pretty good verdict on this. What was it?
It was about $11 million on the verdict. And the jury, by the way, we had a conservative jury in Manhattan on this. I had a reporter from Fox News on my jury. And it was unanimous.
Speaking of juries, when you have a reporter, for example, or even I've seen juries where one of the jurors is a district attorney from another county, for example, okay? Is that good to have those kinds of people on your jury? I mean, it really comes down to voir dire, who you pick, right?
Voir dire is crucial. And again, you can't stereotype anyone. Well, to a degree, look, if somebody is maybe an accountant or an engineer, they have a certain kind of personality that I may or may not want. But again, what's the case about? So the jurors in this case might have been horrible jurors for me in a trip and fall or a motor vehicle case or even a medical malpractice case. But on this particular case, they were terrific for me. So you can't just generalize what they do for how they are as jurors.
When you were speaking about it's difficult to represent a client who really can't tell you what happened or how it affected them, correct? So this is obviously a child sexual abuse case. What is the definition of child sex abuse?
Sex with a child. That's abuse, plain and simple. Children cannot consent. Nobody, whether you're an adult or another child, should be having sex with a 13-year-old child. It's that simple.
Obviously, the jury was familiar with the phrase, and I want you to explain to our audience what a mandated reporter is.
Okay. What a mandated reporter is, for example, if you bring a child to a hospital or a physician, the pediatrician, and they see signs of sexual abuse, maybe anal bruising or something to that effect, they are required to report it to the state or the local municipality to do an investigation. Child services, something of that nature.
And that also applies to schools, like this case, correct?
Yes, it does.
And how quickly do they have to report it?
They're supposed to do it within 24 hours.
So you mentioned a statement earlier that typically their policy was they would wait a week to report it. That's going against the law, isn't it?
It certainly is.
And the police said that, didn't they?
That's what the police testified to at trial.
Don't they know the law?
I think the jury didn't like that defense either.
Now, you kind of answered this question. Can you report a case if you're not a potential sexual abuse case, if you're not a mandated reporter? In this case, the mother did, didn't she?
The child called his mother and kind of explained to her what happened, and she called the police, and that's what really started the investigation.
Do you happen to know how the child is today? This is a number of years ago.
It is a number of years ago. Well, we were able to get a very good settlement at the time. I'm not allowed to disclose the amount, but it was well in excess of whatever was sustained at the time, the highest amount in New York for that kind of case. And he has a trustee, a guardian appointed, so that the money is carefully monitored, because we wanted to make sure he was provided for the rest of his life, that nobody would take advantage of him, and his needs are all being met. We have a guardian that we've had appointed by the court, so he's going to be as good as he can be.
Yeah. Let's talk about, this kind of falls within the category of the American Disabilities Act, correct? Let's talk about the protections that children are guaranteed under the ADA.
Here's a problem in New York State, at least. In New York State, the courts have stated that the ADA cannot be used for purposes of tort liability, which is crazy to me. So let's say it's not even something like this. Let's say it's building construction, and it's not handicap accessible, but it's also just not safe for you or I, even if we're not disabled, to walk on. Or the steps are not safe, or the subway is not safe. They feel that there cannot be tort liability, even though it's architectural engineering standards for all of us that are requirements. And that if that was violated, in New York at least, they can get away with it.
Final words to our audience about if the audience suspects that there's child sex abuse in cases where they have children, for example, in institutions, or with friends or neighbors or whatever it might be. What is the very first thing you should do?
If you suspect it, why do you suspect it? And I've done we had some significant settlements this year for children getting abused in schools in New York City, some by other students, things of that nature. The first thing is the parent should bring it to the doctor's attention or to the hospital. Get the child help. Get the child the therapy that they need to even express what's happened to them, because that's part of the healing process, is not keeping it bottled up. They didn't do anything wrong, and that this way the child will get help. And then because there is mandating reporting, and if it's followed, then hopefully people will find out what went wrong, pick up on the system failure, fix it so it doesn't happen again. But you have to hold the wrongdoers accountable. In that case that we talked about, the system didn't only fail my client. The system failed the assailant. He was a child in need as well. That child also had problems. There was a reason that child was in that facility, and that child needed supervision and help and monitoring. So they really let both of them down, and they really, by putting them together, created an explosive situation that should not have occurred. So they want to sometimes blame the assailant. It's another child that they also screwed up on, that they were negligent in regard to.
In this particular case, you got a verdict against the school, their insurance carrier, whatever. But was there any action taken against the school by regulatory agencies, let's say within the state?
Nothing.
Theoretically, they could be allowing the same thing happening today.
Unfortunately, it happens all too often. I think the municipalities really have not stepped up, whether it be you don't see enough OSHA inspectors out there, you don't see people with schools, hospitals, nursing homes, There's not enough regulatory enforcement.
You know, because you're a very successful lawyer I've admired some of your settlements and verdicts that you've gotten. How do you select your cases? There's a lot of people that will come to you and say, will you handle my case, Bob? What is the couple of primary determinant factors where you decide to take a case?
Well, is there a wrong that needs to be righted? Was somebody unnecessarily exposed to harm? Did a corporation act just in a foolish, unreasonable manner because they didn't care about safety? They cared more about the profits before the safety. And where there's a wrong that needs to be righted so that, one, my clients could be fairly compensated because they were harmed and they didn't ask to be harmed. And two, that it doesn't happen to someone else. If we can hold them accountable, get them to fix it, fix the problem so that it doesn't happen again. And I think that's what happens when a jury gives a significant verdict, is that makes them safer. Doctors are more careful now than they used to be. Cars are safer than they used to be. These lawsuits make us have a safer society.
Okay, well, congratulations on the result, and thank you for being on the show.
Thank you for having me.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.